may I request anybody to, like all of you, to switch on your cameras, like wherever it is possible. Because right now I'm the only person on the screen and all of it is blank. So it will help immensely if few of you can open the screen cameras. Thank you, Upendraji, set this up. Because otherwise it's one talking to oneself is a very difficult situation in this class. So thank you, Ramchandraji, Company Secretary. So all of us are like familiar with the NCLT and NCLAT proceedings. And I wish to keep the entire session as more of a discussion rather than a monologue. So any of you can pose question at any point of time. The more question, the better it is. And I think by sharing the knowledge, we will be able to have fruitful discussion and able to enrich ourselves on these particular topics. Just to start here, like all of us know that the pleadings, documentations and everything is a part of the court proceedings. Be it a lawyer, be it a chartered accountant, be it a company secretary or post accountant, at some point of time, we have given the examination and successfully cleared it. Maybe long time back, 10 years, 20 years, 30 years back, but all of us have cleared it. So we know what are the basic fundamentals are. My endeavor in this entire session will be to revisit those fundamentals. So whenever there is a filing, you encounter less and less objections from the registry. And if there are objections, you will be able to remove them. So the purpose of the drafting is twofold. One, to crystallize the entire grievance of your client in a set of a document. Two, to communicate this grievance to the court. As long as these two principal criteria are fulfilled in your document, it serves the purpose. These are the fundamentals of it. Now, over the period of time, the courts and the tribunals have devised various rules and regulations to streamline the process. So there are multiple types of the pleadings. Like you must have encountered at some point of time suits, writ petitions, special leave petitions, NCLT Section 8, Section 9, etc. All these set of the pleadings have a specific purpose. Some of them are in the original side. Some of them are in the appellate side. The original side pleadings are where the first time you institute the proceedings. Particularly, take an example, if you are going and filing a civil suit, then it is before the district court, original side proceedings. And if the suit is carried into appeal, this is the appellate side proceedings. The original side proceedings normally has the first narration of the story from the side of the profession, from the side of the client, which is completely factual. So if it is a suit, if it is a Section 7 or if it is a Section 9, basically all these proceedings do one thing: collect, collate and present all the facts which is necessary to put the grievance of the client on a piece of document. The appellate side proceedings are a bit different because by the time the first decision comes, the scope of the discussions gets limited to few of the topics. And the first and foremost thing an appellate tribunal is supposed to see, or appellate court is supposed to see, is what mistakes have been committed by the courts below. So it is more like a fault-finding mission in the reasoning given by the courts below before the appellate tribunal. So these are the fundamental difference between the pleadings of the original side and appellate side. In NCLT jurisdiction, NCLT is the original side, NCLAT is the appellate side. I have to make a request again. Can anybody switch on their camera? If anybody is like, right now I'm alone, so I'm not sure anybody is listening or not. Thank you very much, sir. At least one person should be there, so I feel gratified that somebody is listening to me. Thank you. Otherwise, it's completely blank. Even it is, sometimes it feels difficult how to speak and what to speak if nobody is there on the screen. Thanks. So I'll try to make it as interesting as possible and ask as many questions as you can. Hopefully, I will be able to give something or learn something from you. Anyway, so those are the fundamental differences between original side and appellate side. Now, since the tribunalization of the system started, it started long back. Various tribunals came. Now there may be around 40, 50 tribunal systems functioning in India. Some of the tribunals you may have never heard. Armed Force Tribunal, Central Administrative Tribunal, Telecom Tribunal, Prevention of Money Laundering Tribunal, Income Tax Tribunal, Passport Tribunal, Electricity Tribunal, Mining Tribunal. So there are many tribunals, like one can go on. And I think in Delhi, there are 32 functioning tribunals. So the tribunalization started. The tribunal is basically a specialized court which deals with only a specific type of dispute. So when you go to the High Court, you go to the district court, like the variety of the dispute they handle is numerous. But when it comes to a tribunal, they are specialized dispute handling bodies, and therefore they have a very narrow field of view with regard to a particular dispute. And NCLT is one of them. So what is the impact of tribunalization on the drafting and pleadings? Since the dispute is specific, the input data required to decide a particular dispute is also limited and very specific. Therefore, the logical corollary of this is that a form-based practice is being developed. So we can see in many of the specialized act, Income Tax Act as well, to some extent, or any other places where it is possible, they have prescribed from. Even in Central Administrative Tribunal, they have prescribed from. There are various tribunals which prescribe the form that you have to follow this particular format. We need this particular information to decide the dispute. And therefore, the first things which becomes easier for the professional, that only and only these details are required to be placed on record. Thank you, Satish. Secondly, the liberty which is given to a draftsman to put anything in the document goes away, and he has to be pointed towards a particular response. So this is form-based practice, and this is the significant change in the drafting. Be that as it may, there are some fundamentals which is very important for a person who is drafting an application or anything to understand. Every drafting comprises of, first, on the top of it, it asks in front of whom you are going. So, for example, if you are drafting in a special leave petition, if you are drafting a writ petition, or if you are drafting before NCLT, the first and foremost on the top of the line is written, this is the particular court in front of which you are going to make this particular prayer. So, sometimes what happens amongst us professionals, that whenever we go to any court, yeah, किसी से draft मांग लो. Ask somebody to take a draft so it can help us in the drafting. We will follow the same format. But sometimes in those times we forget what is the fundamentals and what if the draft is not being provided. Whether we know the fundamentals, and if we know the fundamentals without there being any help from any other person, we can actually draft. So I'm trying to concentrate on those fundamentals. Whenever you have a question, please feel free to ask. The first and foremost thing in any pleading is the name of the court. Court, sometimes it's the judge, sometimes it's the location as well, along with it. In the judicature of High Court of Delhi, Bombay, etc., etc. But this is the first column in any draft. The next and a very important bracket come is what is the case number. So that is a particular IA number, IB number, suit number, because every registry receives thousands of filings every month. So it is impossible for them to track all those files without there being particular system of managing those. So they have a system where they give a particular number and an year by which they can track the file. So just after the name of the court, the categorization, the case categorization and number. This is the second most important entry in any draft. Once those two entries is completed, the next comes the description of the parties. Who is filing and against whom it is being filed. If you don't tell who are you, then the court doesn't know who it is. So the next thing which comes in the matter of 1ABC, then in front of that person, you are supposed to write in what capacity he is filing, whether he is a plaintiff, applicant, petitioner, appellant, etc. These are the different nomenclatures which is used in the first description of the party. So one is the description. So ABC, say he is an appellant or applicant, and that thing is over. Now, after the appellant and applicant, sometimes there is a slash and S, whether there is a one or multiple. So say Ramlal and others, and Ramlal and another. So that another signifies that there are only two, and others signifies there are multiple of them. Therefore, just by reading the memo or the first description, it becomes clearer to the person who is scrutinizing that application, be it a judge, be it a registry, be it a respondent, but there are one party or there are multiple parties. Then comes the second portion of it, which is the respondent. Somewhere it is called respondent, somewhere it is called defendant. But there are only two. In the first column, there could be multiple of them, but in the second, there are only few of them. So once that particular description is complete, then your header is complete almost. Then you have to tell under which provision or what kind of applications or what kind of petition you are filing before the court. So this is a kind of a subject tagline. It's a subject tagline which says that this is an application under Section 7 of the IBC, so and so forth. If it is appeal, you say that appeal under Section 61 of the IBC before the appellate authority, and so and so. So this is the subject tagline. It is almost universal in any court. So you have to describe what is this, so they know under which section you are coming. Sometimes if you are not able to specify the section, then the objection comes from the registry that you haven't mentioned the section. Your petition goes into objection unless you clarify it, it doesn't get listed. So that's the column of the subject. Now, the middle part comes. The middle part comprises of normally the cause of action, limitation, jurisdiction, prayer, etc. Now, where there is a form, like in adjudicating authority rules, there is a form prescribed divided in multiple parts with each column requiring specific information. If there is a form, obviously the form has to be there. In case there is no form, it starts with the facts. These are the facts which giving rise to cause of action. And even the form follows the same thing. The form basically tries to extract the information which gives rise to a cause of action which gives you the right to remedy. So all those things has to be mentioned. Once you mention the chronological facts, then what are the grounds? You have to inculcate those grounds into your pleading. And based on the grounds, you say that why you are entitled to a particular kind of relief. So the relief is mentioned, and at the bottom of your thing, there is a verification and there is a signature. So this is a broad fundamental pattern among all the pleadings. This is a general pattern. It is not specific, but it is a general pattern. Any questions so far by anyone? I assume that everybody has learned everything, but be that as it may be. So where do we get all these rules and regulations and etc.? So probably all of you might have read at the time of passing your examination, NCLAT rules. They are the better ones. So I'll just, what I'll do is I'll just share the screen, which is the NCLAT rules. These rules are, gives what is the broad guidelines for, I have just opened the IBBI website. IBBI website, I have taken out this particular notification of 21st July 2016. These are National Company Law Appellate Tribunal rules, and the fundamentals which we have discussed so far is also laid down in these rules. So, what are the important definitions in these rules? Act is an act, advocate is an advocate, appeal is specific. Then form means that the form set forth in Annexure A. So they have already said that this will be form whenever, wherever the form is specified. Interlocutory applications. So there are lots of IEA. We know them IEA every day, IEA, so for 1, 2, 3, 4, whatever it is. So these are interlocutory application. It means an application in any appeal already instituted in the appellate tribunal. So first there has to be a case. And in that case, if you are filing an application, then it will be regarded as interlocutory application, but not being proceedings for execution of the order or direction of the appellate tribunal. Execution is separate, contempt is separate, but all other applications will be regarded as interlocutory applications. Then party. The definition of party is also important. The party means person who prefers an appeal before the appellate tribunal and includes the respondent of any person interested in the appeal. So one who filed, one who is responding, and if somebody got himself impeded in the entire process will also be regarded as party to the appeal. Section everybody knows. Now one of the important part is computation of limitation, because all those pleadings have one thing which is in common. is what will be the limitation. Where a period is prescribed by the Act, and these rules under any other law is fixed by the appellate tribunal for doing an act in computing the time, the day from which the said period is to be reckoned shall be excluded. And if the last day expires on the day of the office of the closed, that day and the succeeding day on which the appellate tribunal remains closed shall also be excluded. This is a general rule which is applicable in computation of the limitation at all point of time. Why it is important? Because the condonation power is very limited. There are multiple litigations which has happened involving this particular rule. Why? Because it says that 30 days plus 15 days for the appeal. So when the 30 days commenced for filing of appeal, it starts on the day when the judgment is pronounced or the day next. So this section answers that the first day on which the appeal is filed, the judgment is pronounced is to be excluded and the computation starts from the next day. What if the 30th day is a Saturday or a Sunday? Then that limitation will expire on Monday when it is being filed. So if the limitation expires on a Saturday or a Sunday, when NCLAT closed or for any other holiday, then the limitation will expire on Monday and not on a holiday. It is possible nowadays to file 24 hours. E-filing is there. But this rule is still there that if the limitation is expiring on a holiday, then the computation has to be done as per this section. Merely because there is round-the-clock filing facility, it doesn't obliterate the benefit given under this section. This is part number 2. Third, there are multiple judgments which has come now that, that the order was not uploaded. So one of the arguments which was being advanced by the people that if I want to file an appeal, I need a copy of the order. If the order was pronounced in the open court, and if I don't have a copy of the order, how can I prepare an appeal and file it? The answer to this question is very specific. Once the order is pronounced in the court, then your time begins to run. If you do not have the copy, it is obligatory on you to apply for a certified copy. The day when you apply for a certified copy and the day when you actually receive the copy will be excluded from the period of limitation, excluded from computation period of the limitation. So one cannot say that I will wait for filing of the appeal till I get my free copy. In some of the cases, the people said that NCLT passed an order, it was not uploaded for a month, and thereafter, when it was uploaded, we prepared the appeal and filed, so therefore condone the delay. No, this is not the way the system works. The system says that once you got to know that the order has been passed, then it is your responsibility to find out what is the order. You are supposed to apply for the certified copy. And if the certified copy takes 1 month, that period may be excluded. But you can't say that when the order was uploaded, then or the free copy is served upon you, therefore the limitation has to start from the free copy. So that's just regarding the limitation. And in the draftings and pleadings, one of the important things which again and again comes up is power to condone the delay. The litigation has gone from the NCLAT to the Supreme Court multiple times. Supreme Court leaned in the favor of the strict interpretation for the purpose of limitation of the IBC. Like beyond 15 days for which the delay can be condoned by the NCLAT, nobody has, even the NCLAT does not have the power to condone the delay. Since power is not there, come what may or whatever may be the reason, the delay will not be condoned. In between, there was some jurisprudence which said that if there is a delay of 15 days, whether there is a proper explanation of that or not. So, your delay application, if you are going to draft, you must give the explanation from day to day. Like what happened, whether the person was not well, the documents could not be arranged and everything. If your application is lacking the reason for condonation of delay, it can result into dismissal of the appeal itself. Any questions so far from anyone? No? Thank you, Bhupender ji. It would be better if some of you can ask some of the questions because it helps. Right now, everybody has gone back to the incognito mode. But see that as it may. Let's see. So the next thing, which is the power of the adjudicating authority or the appellate authority to give procedural directions or rules. You must have seen multiple times the NCLT and NCLAT issues directions, and because of those directions, the rules gets changed. So take an example, in an IA, there is a direction that one has to mention the name of the case IA first and then the name of the case second. There was a direction to give list of dates. There was a directions. Yes, in PG cases, there is a time frame. So somebody asked that question. Could you please switch it on your mic and tell, sir? It will be really helpful. Please switch on your mic.
Sir, I have one query. Just a minute, sir. Sir, I am audible?
Yes, you are audible.
Hello?
Yes, sir, you are audible.
Sir, I have one query. One query regarding the limitation in CD cases, CD2 CD cases. Is there any requirement? Is there any provision that there should be specific the time gap between the filing of Section 7 application and Section 95 application should not be more than 3 years or so? Is there any provision?
No, there is no such provision. The remedy under Section 7 and the remedy under Section 95 is independent remedies. Like one can file Section 95 and Section 7 in one go. Okay. Now,
so if
so yes. Now there is a case law which emerged that if there is an invocation of the guarantee, so Section 7, the cause of action incurs from the date of default. So suppose a person doesn't pay EMI, then the date of default is crystallized. They have to institute the proceedings as per Article 137 within 3 years. Okay. So 3 years, Section 7.
And
in case of personal guarantee, the cause of action arises when the guarantee is invoked. So if the guarantee is invoked and within 3 years the proceedings are not instituted, then it will be time barred.
Right. Okay. Like if Section 7 application is the NPA was date of NPA is, for example, year June 2019.
Right.
And Section 7 application is filed in December 19. Right. So Section 995 application can be filed in year 24 if guarantee is invoked 3 years before the date of filing of application under Section 95.
Yes, yes.
Right.
So for section 95, the date of NPA is not relevant. What is relevant? The date of invocation of the guarantee. The limitation will begin to run when invocation notice is given.
Right.
Am I
Right,
clear,
sir.
sir?
Thank you very much.
Okay, thank you.
Yes, sir.
Okay. So coming back to the main topic, and thank you very much for the question, Bhupender ji. So coming back to the main topic again, institution of the appeals and the procedure. This is very important, so I will read it and explain it. So you will have a good idea why a pleadings has to be drafted in a particular manner. So what it says, every appeal in appellate tribunal shall be in English, so it cannot be in vernacular. And that is the reason one is supposed to file the translated copies of any vernacular document because of this rule. And in case it is in some other Indian languages, it should be accompanied by translated in English and shall be fairly and legibly typewritten. So fair and legible. Most of the objection regarding filing comes fair and legible. Fair and legible is normally like font of 12, spacing of double, etc., etc. Printed in the double spacing. So the spacing has to be double. On one side of the standard paper with inner line margin of about 4 centimeter width on the top, with right side margin of 2.5 centimeter and left side margin of 5 centimeter, duly paginated, indexed and stitched together in paper book form. Some of it has become obsolete, but some of it is still relevant. One is the margin, two is the spacing, and if it is the paper, like most of the questions comes like what should be the paper, whether it should be legal, A4, green paper, etc. So the NCLAT standard size paper, A4 paper works. There is no need to have a legal size paper or a green sheet, at least in NCLAT for sure. In NCLT also, in some cases, there might be some tribunal which may be still following the old process, but this is what the statute book says. And this is applicable across all the tribunals and appellate tribunals, like particularly in Delhi and Chennai bench of the appellate tribunal. The case title shall be in the National Company Law Appellate Tribunal. That's what I said. Once you go to the court, you have to specify at the top what is the court. Proceedings authority against appeal shall be divided into paragraphs, shall be numbered consecutively, and each paragraph shall contain as nearly as may be a separate fact or allegation or point. This is very important. Irrespective of in which court you are drafting the proceedings, what you should do, I'll read it again, and it's extremely important. Appeal shall be divided into paragraph. There should not be like one page, one paragraph. It should be divided into, and shall be numbered consecutively. Like you cannot give any number what you want, A, B, C, D, 1, 2, 3, 4. 1, 2, 3, 4 consecutively. And each paragraph shall contain as nearly as may be a separate fact or allegation of point. You can't jumble the entire story in one paragraph. The one paragraph should communicate only one idea. So the person who is reading that paragraph has a clear thought and is not required to do extra effort to understand what it is. Sometimes a very pertinent questions comes whenever the people are discussing drafting, whether the language is legal or not, whether one should use jargons or not. that one particular drafting is extremely good and one particular drafting is very bad. Some of you might have seen the picture like Jolly LLB when there are various comments are made on the draftings. But be that as it may, the purpose of drafting is very simple. Communication of the grievance in a logical manner from the client to the court. As long as the communication is simple, to the point, and the judge is able to understand easily, then the drafting is good, irrespective of what jargons or language it is used in the drafting. I hope I'm clear so far. So, any questions so far? I think that there are a lot of people who are very knowledgeable. I recognize few of the faces. Anyway, anybody can switch on their camera. All of them have switched it off.
Good afternoon, Manish.
Good afternoon, ma'am.
Yes, actually, sir, I cannot switch on my camera right now, but I'm there in the meeting.
Otherwise, it feels like everybody has left.
No, I can understand this. That's why I just unmute myself and responded to you.
Okay, thank you, ma'am. Thank you.
Yeah. Okay. Thank you, sir.
So the next thing is the calendar has to be the Georgian calendar. Then the next important point, which has been mentioned in these rules, that the name of the parties shall be numbered consecutively and separate lines should be allotted to name and description of each of the parties. And these numbers shall not be changed. And in the event of death of any party during the pendency of the appeal, his legal heir or representative, as the case may be, if more than one, shall be shown by sub-numbers. So this is very important because once you give a nomenclature, he is a respondent number 1, or respondent number 2, or respondent number 3, or appellant, or what appellant number 2. The number remains the same throughout the entire proceedings before that particular forum. It might change in the appeal, but before that forum, the number remains the same and it should not be changed. If you change it, then it is likely to cause confusion in the minds of your opponent, in the minds of the judges, and there is higher chances of that you may not get the desired outcome, even if the things are in your favor, because the person will not able to understand the entire storyline and it will likely to get confused. In case there is a death, then this particular rule, in this particular tribunal, it says that it has to be subset. So the numbers will be say 1, A, B, C, etc., etc. That has to be there. Then what happens if the new parties are added? 7, where fresh parties are brought in, they may be numbered consecutively in a particular category in which they are brought in. So whether it is a petitioner or respondent, if petitioners are added, then they will go like subsequent. If there were earlier 2, now it will become 3, 4, 5, 6, and amended memo of the parties is to be filed. Every proceeding shall state immediately after cause title the provisions of law under which it is preferred. So the first subject tagline has to be mentioned. What is it? What it should be? Under which section it is filed. There are omnibus sections as well. Section 60 subclause 5. So all the applications in the NCLT is filed in that particular section. And if you don't know, it's advisable to use inherent powers or the residuary powers, 11 or 60 sub clause 5. So you can get the desired relief and get it clear. Then section 20 deals with the particulars of address in the service. It has to be taken from the memo of the parties. So it should mention all these details in the memo: name, town, post, presentation of the appeal. Right. Now, the presentation of appeal is also important. Every appeal shall be accompanied by the certified copy of the impugn order. In case the impugn order is, you are not able to get the certified copy, you can annex the internet copy of it, but along with that, you are supposed to file application for exemption of filing the certified copy. In that case, you will not get the benefit of exclusion of the period from the obtaining the certified copy. Then all the documents filed before shall be accompanied by an index in triplicate containing their details and the amount of fee there paid thereon. So index is mandatory. Thank you, Nishiji. Perhaps you are in air flight, but thanks for switching on the camera. In the pending matters, all the applications shall be presented after servicing copies thereof to the advance copies to the other side. So, in case the advance copy is not served and the proof is not filed, your application will not be listed, and this is because of this particular rule which says that advance copy has to be served. The rule regarding advance copy is very peculiar to the jurisdiction of the tribunal, because everything in the IBC is a time-bound process. One of the way the proceedings can be made time bound is that the person who is going to oppose you knows exactly why and what he is supposed to respond. So there is nothing to hide. All the people should have same document, be it the counsel for the petitioner, respondent, and the judge. Then only the proceedings can move fast, and therefore the advance copy is required. However, this is not case in all the tribunals. If you are filing an appeal in the Supreme Court, there might not be a requirement of giving an advance copy. In many of the, but in NCLT and in NCLAT, all the copies have to be served in advance. The proceeding fee prescribed by the rules, the required number of envelopes is sufficient. That's not something relevant. One is endorsement and verification. This is very important because sometimes the people forget to put the declaration and verification in NCLT and NCLAT appeal. There is a specific format prescribed and that has to be strictly followed. So what it says, at the foot of every appeal or pleadings, there shall appear the name, signature of the authorized representative. And every appeal pleading shall be signed and verified by the party concerned in the manner provided by these rules. So in NCLT, they insist on signature on every page. In NCLAT, it is not required, but still the declaration is to be required. Then translation of the document is also important. It has to be in English. And endorsement of the security. Yes. So endorsement and scrutiny of the petition or appeal or document. So once you file it, for all these compliances, the registry checks those appeals on all these criteria, whether it meets or not. And in case it doesn't meet, then the objections are pointed out. One is supposed to remove the objection as per these rules and regulations. Once they remove it, then only it is listed before the NCLT or NCLAT. The practice which is being followed in most of the tribunals, they intimate the objection once, you remove them, then they give it twice, you remove them, and then it is finally listed. In Bombay, or maybe in some other places, the NCLT has started listing Section 63 applications before the tribunal, where if the objections are not removed within the time, then it goes before the court and court decides to condone it or not to condone it. That's a new practice which has emerged. In case there is an urgency, then in tribunals, particularly in NCLAT or Supreme Court or some other tribunals as well, you can request the court or tribunal to list the petition with defect. If the court allows it, then it will be listed with defect, which can be removed later on, or sometimes they are never removed ever. So this is the process, whether you have followed the above or not, is checked and then listed before the court. If all these guidelines are followed in letter and spirit, the number of objections which you will encounter from the registry will get reduced significantly. But all these people are heavily under the burden of filing, so they point out objections sometimes, even if there is hardly any reason to give those objections. Registration of the proceedings admitted, production authorization, this is all. Then the next important thing which comes for the pleadings and drafting is the form. So all these rules, we can see NCLT form rules, whether it has been provided or not. So as we discussed, Companies Act, National Company Appellate Tribunal, New Delhi, jurisdiction, that cause title A and B, details of the appeal, date and impugn, the address of the appellant, etc., etc., the address of the respondent, the jurisdiction of the tribunal, limitation, facts of the case, question of the law, grounds raised, matters not previously filed with any court declarations specified below index. So this is the format which is to be followed. I just want to say there was some question. Yes, Bhupender Sethi asked a question. Kindly guide if any additional cause of action is required against the same respondent on the basis of certain additional enforcement. Ideally, existing application should be amended or new application should be filed. In existing filed application, notice is already serviced to the respondent, kindly opine. Bhupender Sethi, could you explain the situation more better? I'll try to answer.
Sir, this is regarding some application under Section 66. That application was filed almost 8 months back.
Right.
And now some additional future transactions has been found.
Okay.
So I just wanted to know whether I should go for additional new application or existing application should be amended.
Okay, so the Section 66 is avoidance on fraudulent transactions. Normally,
Yes,
the party involved is ex-director plus someone else. Okay, it might be respondents. Could you please repeat, Bhupender ji, आपकी आवाज कट गई थी.
Just a minute, sir. Sir, I'm saying respondents are same in both.
Okay, even if
parties are same, basically.
Even if the parties are same, if the transaction is completely different, then you have both the options: amend the existing application, incorporating the grounds, or file a new application. It is advisable to file a new application regarding the separate transactions, so it will be easier for the bench to comprehend the facts and give a decision. However, there is no rules and regulation that all the transaction has to be clubbed in one particular application. If you recollect earlier, there was orders from the bench that for each transaction, separate application to be filed. Then ultimately the matters traveled from the NCLT to NCLAT and Supreme Court, and then they said that each types of applications has to be segregated. Then the recent ruling is, as long as the transaction has been specified, there is no need to have a separate application, something on that line. Be that as it may, since you have noticed those transactions subsequently, it is advisable to file a separate application, which will help you to meet the timeline before IBBI as well, that you have filed those application at the first instance, thereafter further transaction advance, so you are always in compliances. Two, even when the application deals with one transaction, it is easier for the judge to decide the case and give the judgment on that particular transaction. Is it clear, Satisam?
Yes, sir. Yes. Thank you very much.
Thank you very much. So, I'll just take one by one these clauses, and I can say that how one has to, so there is nothing like details of the appeal. Everybody writes the numbers from the lower court, when was passed, by whom it was passed, so they know the appeals. Then the jurisdiction of the appellate tribunal has to be mentioned. It's a standard clause. Everybody says the same thing, but there are occasions when this very particular clause comes into the question. Because unlike other appellate forums like the civil court or a high court or a Supreme Court, where the jurisdiction is very wide, the jurisdiction of the NCLAT is circumscribed by the section 61. It says that only those particular things can be seen in that window. If there is an order by the NCLT, it can carry it into the appeal. In case you goes beyond the jurisdiction, or if you haven't taken that particular decision from the NCLT, probably you might not come in an appeal before the NCLAT. Thank you, Anupam Ji Tiwari sir, for switching on the camera. Any questions, sir? Okay, so I think he has gone back. So that's the jurisdiction of the appellate tribunal. Limitation we have already discussed. Now the next important thing, facts of the case. In facts of the case, the most important thing one must keep in mind is that they have to be chronological. Why chronological? It says that give here the concise statement of chronological order. So the event happening in 2002 will always be written prior to the event happening in 2005. One should never write a story in the flashback mode because it is very difficult to understand. So typical IBC story is loan applied, sanctioned, disbursement happened, repayment only till date. On this date, the default has happened. And thereafter, A, B, C, D, these proceedings were initiated. Thank you very much, Nitiji. So,
You are most welcome, sir.
thank you. So at least one face is visible, then I'm confident, yeah, I'm doing something. So, but do you have any questions, ma'am?
Actually, sir, I really wish to learn how to file this appeal and application. That's why I'm listening it carefully.
Okay, thank you. So as long as you follow this format, you will be able to learn everything. And if you have any doubt, you can always ask me in this session or anytime afterwards as well.
Thank you, sir.
So the thing is, the facts have to be narrated chronologically, like it has to be a logical sequence. It is also important for the section 66 and other avoidance transaction applications, because sometimes the people write the story as they come to know. In 2005, I come to know that the transaction happened in 2001. Okay. No. that will not work. You have to write 2001, it happened, it was concealed, and it was discovered in 2005. Never write backwards. It helps the person reading the story easily. So you see any of the films, any of the religious books, very few of them are in flashback. Most of them go straight like one event, two events, three events. Then followed by the elaboration of the issue, including question of law arising in the appeal. So when you are drafting that particular question of law, say but you are drafting the question of law regarding acknowledgement. You are saying that there was OTS and therefore an acknowledgement, therefore the limitation starts to run from that particular date. So the grounds has to be written in such a manner that it correlates with the fact. Law and facts has to be intertwined, so the arguments comes up to very clearly and the judge is able to understand. I'll repeat the same example. Say a person says that the default happened in 2001, the account was declared NPA in 2005, and OTS came in 2008, and therefore, and the petition was filed in say 2010. So the person is taken the argument, say before NCLT, that the limitation starts from the date of default or the date of NPA, and therefore this petition was time barred. So the reverse argument or the counter argument in this very proposition will be, since there is an acknowledgement in 2008, every acknowledgement under section 18 gives the fresh right or cause of action. It revives the cause of action as per section 18 of the Limitation Act. Since in this case, the acknowledgement in the form of OTS came in section 2008, therefore it is within the period of limitation. So that's what it means, that elaboration of issues, including question of law arising in the appeal. Each paragraph should deal with, as far as possible, a separate issue. Never try to club. Even on the above issues, it has been specifically mentioned. So this is what it is. Paragraph 8. Facts in issues specifically in dispute between the parties summarize the question of law that gives rise consideration of appeal. This is something which is typical to all the appeals, where they ask us to specify question of law. Fact in issue is typical to NCLAT. Question of law is also there in High Courts and the Supreme Court in NCLAT. The reason behind this rule is that the appellate forums are the forums which determines the law which is being followed. They are not the fact-finding courts. For example, a civil court is a fact-finding court. It gives the finding on a particular, say that possession was there or not, default was there or not. Even in NCLT, is the fact-finding court as far as default is concerned. So those are the fact-finding court. When it comes to the appeal, they are law deciding courts, and therefore you are supposed to give question of law. But with the age of AI, and these things have become very easy to draft. You put a preposition and it will frame a question of law. Earlier, it used to be a very intellectual job and it was very difficult to draft. It used to take months and months of practice to draft question of law. So the draft, so what is a question of law is also a skill to learn, because every question of law is not a question of law, because if it has already been decided by the appellate court, then it will not remain any question in law because it has been answered. Then, if the question is of a fact, whether there was a possession or not, or whether there was disbursement of no. So this is also not a question of law. There is a third category which was carved out at some point of time, which says mixed question of fact and law. So limitation, for example, is a mixed question of fact and law. In NCLAT, fortunately, there is no rule which says that if no question of law arises, the appeal will be dismissed. But lawyers know very well that if they go into second appeal, and if they do not formulate proper question of law, then the appeal is liable to be dismissed. Here it is still open. It helps the tribunal to crystallize the issue and decide it. So it is more of a form-based requirement without any adverse consequences. Adverse consequences in the second appeal CPC, where the case will be dismissed if there is no question of law. In NCLAT, there is no adverse question of law. Then grounds raised with the legal provision. So one must get confused always, like why it is so that in facts I have to write the facts. Then again in the question of law I am supposed to write the facts. And then the third time in the grounds I am supposed to write the facts. So this is something. Excuse me. So these rules were devised to help the judges in the most effective or possible way. So what they were supposed to do, that when you say the facts, they are just trying to understand the story. When you come out with fact and issue, is like issues are framed typically in a title suit or like whether there was any default or not. So those were the issues. Question of law, whether there was acknowledgement or law by virtue of the entry in the balance sheet. Question of law. Then grounds. Grounds is the answer of all the above. So first is the storyline without any law or with some law. Two is the questions raised, like what questions emerged from the story. And third is your answer from the side of the litigant. This is the answer to my question. So it is the same thing getting repeated thrice, but in a different format. So it will help the judges when they are supposed to dictate a judgment or write it or give their rulings, they can take help of these and do justice with the parties. So this is why it is there. Ideally, when you start drafting, you can draft any of those first and then apply your mind, and the other two byproducts will come automatically. If you have done your homework in the grounds, you can easily cull down the question of law and fact in issue, and facts are always there. If you have done the facts well, you can cull out the question of law, and based on question of law, you can cull out the grounds. So drafting is easy. It's the three things, thrice it is repeated. First is the fact, second is the issues raised on those facts, and third is your answer, that is called grounds. You always say because, you start the phrase with the because, or the tribunal has failed to understand, or whatever the format you would like to choose. There is no specific requirement, but this is the chronology or sequence. Then comes a declaration, matters not previously filed or pending with any other court. This is also a requirement which they have typically borrowed from the writ jurisdiction. It is possible, it used to be a frequent practice that the people used to do forum shopping for a particular relief. They file in one court for the one thing, and if they're not getting the relief, they were filing it another court with a different set of things and not disclosing. So gradually the court started introducing these clauses which says that you have not filed the matter at any other court. The situation hardly arises in NCLAT because there is only one NCLAT or maybe two benches of the NCLAT. The chances of filing against the same order before any other court is rare. There might be some instances where some people might go to the writ jurisdiction for Article 227 against the order of the NCLT. But the chances are not too many. Specify below explaining grounds for each relief and the legal provisions, if any, relied upon. This is, in my opinion, is again repetition. So basically you make a summary of it and put it in one paragraph and it works. So you need not repeat everything which you have put in the grounds here. You simply make a summary of it, a very short summary. It's very easy nowadays. You can use AI or whatever it is. Any of the AI is good or it. You can make a summary and put it here. The next important details of the interim application, if any, preferred along with the appeal. This is important. All the applications has to be mentioned here. So detail of the index and system. So with that, we conclude the entire form which one is supposed to use for filing of the appeal in NCLAT. So far, any questions by anyone? Any questions, sir, ma'am?
Manish, not a question with respect to this. I just want to want to know about limitation. You were
Yes.
saying when it's a Saturday, then it will be the next working day.
Right.
Right. But I think I am confused in negotiable. They say if we know about that is the last day is going to be a public holiday, then we shall take it one day before for the limitation.
No, no. In court, it is settled. The section, it is very clear. If somebody tries to give that a philosophy, you can simply show him in the section. I think it was computation of time period. Okay, so I'll read it again. This is it. Where a period is prescribed by the Act and these rules under any other law or is fixed by the appellate tribunal for doing any act in computing the time, the day from which the said period is to be reckoned shall be excluded. And the relevant part starts here. If the last day expires on a day when the office of the appellate tribunal is closed, Saturday it is closed, Sunday it is closed, public holiday it is closed, that day and any succeeding day on which the appellate tribunal remains closed shall also be excluded.
Thank you. Thank you, sir.
So it is extremely clear. The same section is repeated in the Limitation Act as well and here as well. So irrespective of the tribunal, this rule will be applicable.
Okay,
Thank
sir.
you. Thank you, Preeti ji, for the question. Any other question? Kapil ji, your camera is on. So any other question from your side?
No, sir.
So like, am I clear in communication?
Yes, yes, absolutely clear, sir.
Okay. Thank you. So this is like sum and substance. Like the topic was had a limited scope to say just a second. The topic was drafting so there are like I wish to dwell upon some of the questions which come frequently, like none of you have asked, but still like those questions are asked by the people when I took the
Manish,
session. Yes.
there's one query. Can we have a glance at any of the appeal or something in practice that you have actually prepared? Means it's without the name, but I just want to see format in which they are going. Means the format is clear from the rules itself, but any practical example for the same if we can see.
You drop me a message, I will forward you an issue.
Okay.
It's lot of work to remove those name and details. And
Yes, yes.
sometimes if you remove all the details, there is nothing left in it. But
Okay,
I will forward it to you, not an issue. Okay.
okay, okay. Thanks.
So in first,
Your number, sir?
yes, I'll put it in the chat box.
Okay, sir. Okay.
So think just a second. So yeah, this is my number, and this is, I think, my mail ID. Yes.
Thank you, sir.
Right. So the drafting, pleading, and arguments was the total topic. So out of which drafting and pleading we have covered for the NCLT and NCLAT. Arguments is the third limb. So the how to prepare for the arguments. This is an art which has to be learned over a period of time. Nobody becomes expert unless they practice it themselves. A person may be very eloquent, but he may not be able to communicate with the judge. Sometimes the people are not so eloquent, but they are able to communicate what they want and what is the legal proposition in very few words. There is no golden rules, but the first rule of preparing for the arguments is being thorough with your own facts. So if you are extremely thorough with your facts, then you will be able to argue well for sure. The second, you must be thorough with the law. You need not know everything under the sun. You are supposed to know what is applicable in your facts and circumstances. As long as you have done your research, as long as you have your judgments, as long as you have command on the facts, you can argue really well. Now, one must understand that lawyering is all about the communication. There is only two products which comes out from any skilled professional before any court of law. One is pleadings, drafting pleadings, and two is the argument. The purpose of both the output is the same, communicating the idea from the point of view of the client to the judges. As long as that basic principle is followed, you are good. But in order to communicate, it is very important for you to know what the other person thinks about it. When a person is sitting in the corridor or maybe watching the proceedings, sometimes they feel that the judges are not doing the justice. Sometimes they feel that, okay, I know the fact, why he is not able to understand it. Sometimes the complaint is, why Tariq pe Tariq? I'm able to give every assistance to you. Sometimes there are discussions about the corruption and etc. Be that as it may, one must be mindful of the fact, which very few people realize, that every judge is supposed to go through 50 briefs in a day. Every brief contains 500 pages. It is humanly impossible for the judges to be conversant with all those facts and law in every case. So, the typical misconception is that they are a superhuman being. No, they are human being just like us. They are supposed to be told relevant facts. They also have they also want to understand the things very quickly without going into the details, which is very humane. And therefore, you have to tailor your argument according to the judge. If you are not able to do it, you will not be as successful as you should be. One of the rules one can follow while arguing before a court is to listen the court very carefully. Unless you are able to understand the question, you will not be able to answer. Many a times, in the anxiety of the argument, when the people are appearing or as a resolution person, you are appearing before the court, you anticipate the question and you answer it. That irritates the person the most. That you are not giving him the space to tell what he wants. So, whenever the judge asks a question, you have to be very patient, listen it, and start speaking only when he finishes. One of the key things in the argument is like you can win case just by knowing the judge. There is a proverb, like I'm not recollecting the exact words, but if you know the judge, you can win the case. That doesn't mean that there is some extra thing happening behind the back. Knowing the judge means what exactly he wants, what question he is trying to pose, and what you are supposed to give the answer. The attention span of every person is limited. Unless you answer the question, he will lose the interest in your case and it will not be decided in your favor. Another thing, one, patient listener. Two, answer only when he says. Third, when the judge is firing on the opponent, keep your calm, be patient, be silent. You will be able to understand the judge only when you listen to him very carefully, what kind of questions he is posing. It gives you an idea whether he has read the file. It gives you an idea whether he knows the law or not. It gives you an idea whether he is trying, is there any misunderstanding which you can clarify? It gives the idea sometimes they are just tired, whether they want to hear it or not. There is no purpose in arguing or going into a lengthy argument when the judge is not interested. Sometimes they are not well, sometimes whatever it means. So never press that it is my matter of right and I will decide and he will decide fairly. They are human beings and they have their own process and experiences, and based upon which they make the judgment. Another thing which you are supposed to prepare when you are trying to argue is anticipating the questions. As you are preparing for the exam, the first thing or the last thing one do is going through the question papers of the previous years. This applies in the case of argument as well. It's a kind of a viva voce or an interview, and it's every day taking place one after, like every hour. If you know the questions in advance, it's very easy to answer. So suppose if you are going to appear before a tribunal, it is advisable to watch the proceedings of that tribunal. You can go earlier to the tribunal, you can watch online, whatever it may be. It will give you a fair idea what kind of questions can come. So take an example of Section 7 application, what the judge asked. Disbursement, loan amount, date of default, whether RP's authorization has been filed or not. That's it. There might be 100 things written in your application, but he is not bothered about that. He is only looking for the information which he requires to make that judgment. As long as you provide those informations, he will be happy. He will not be happy if you try to cut him short, if you do not answer or if you do not provide with the relevant information. So it comes with the fact that you spend more and more time in the court or virtual hearings, and then you get to know. Any other questions so far? Okay. So I assume that everybody learned everything. And
Yes, sir. It's an insightful thing to be patient enough to listen to a judge. But to the extent I don't have that much practical experience, but what I feel is the thing when he is not ready to listen to your point, obviously, then I think there is no scope of argument at that particular point of time.
right.
Right? Is there any alternate to that?
Yes, take a date. If the judge is saying that can we have it tomorrow? Are you going to take too much of time? Can this
Okay, okay.
be sorted
Yes.
out? That means that he is hinting you ask for it. He will give it.
Okay, okay. Thank you. Thank you, sir.
If you want, if you still insist, then he, he, he well, sometimes you get tired, na? If there is a movie, see, think from a perspective of the judge. He has to see people only in black and white from morning to evening, pressing for the argument, same repetitive argument, loan, default, non-payment, loan, default, non-payments, 100 times a day, one from the mouth of the petitioner, one from the right mouth of the respondent. Okay. So as a human being, he will get bored. Okay, it might be the most
Yes,
important
yes.
case for you. Say that I
Right,
have
right.
100 crore of default. This is most important. Decide it today for him. Like I mean, I have done say so many 100 crores.
Right, right. Absolutely correct. Right.
So those things have to be very careful. Another thing is formulating the argument. Normally, it is very difficult for a judge to remember everything, like any other professionals. He can't remember all the 50 cases. And he can't remember all the arguments. Don't come out with, say, 15, 20, 30 arguments. Make it in the single digit, maybe 3, 4, 5, which makes your case winnable, and press for those. No purpose in telling the entire history, geography of the corporate data, or if you are for the corporate data for the bank. If you get too many details, he is going to lose interest. He or she, whoever it is. Then also you have to be very cautious about the way you address the court. Most of these people have reached to this post in an age where they want themselves to be respected. So there should not be a slightest hint of disrespect. They can't go into your heart or head. Appearance matters. Some of the judges gets agitated if the professional is dressed as per the institute requirement, like blue, white. For lawyers, it's white and black. It has to be there. Then from morning to evening, they have the habit that everybody says yes to them, so don't start with no. So all those things are like, these things are typically called as court craft. It's very difficult to teach in, like one can teach in other lessons. It doesn't happen. It has to be like a practice, like a cycle or a swimming class where like everybody knows the theory, but unless they do themselves for a pretty long period of time, say for 15 days, 20 days, 30 days, they don't learn it. So everybody knows cycle, you have to say straight up front, see straight, and move your feet like in a circular motion, but it takes months for a child to learn it. If somebody starts learning it in advanced age, it takes more time. So same is the case with the argument. Like I can tell you 100 things, but unless you do it yourself, it will not work. Sometimes the court suggests frequently that why don't you go for the mediation? That question has two connotations. Don't force me to work and decide your case. And two, the mediation is always better. The answer has to be yes. Even if mediation fails, the answer has to be yes. One must try it for it. Facts and figures, it's better to be on your tips. And even if you don't know them, make a small chart, take it in the court, give it to the copies of the court. Always carry your judgments with you. And it is advisable to highlight or put the numbers on it with the relevant paragraphs. Sometimes the judgments are like 1,000 pages, one judgment, 1,000 pages, two judgment, 2,000 pages. Nobody is going to read them. The purpose of writing of judgment is to explain the rationale. So that's why they are very lengthy. They give all the plausible reason to reach at a particular conclusion. So nobody reads them entirely. Everybody wants what principles of law it lays down in what facts. So you must highlight the judgment, the relevant facts, and the relevant law. So judge can easily read it in a minute or two and say that whether it is in favor or against you. Apart from that, the ultimate output which comes from this entire exercise is a judgment or an order. So the rule can be summarized like that. Whatever is relevant to write that particular document for a judge should be part of your argument. If you feel that for any reason, anything which will not form part of that document in your favor or against you, that is irrelevant, should not be argued, should not be put in the pleadings. Because there is no other output which is going to come. Say, take an example. Sometimes client comes to you, says a corporate debtor, he says that मेरे बच्चे बीमार हैं, मेरे पिताजी को तबीयत खराब है, आप ये भी लिख दो, humanitarian हो जाए कुछ. Okay, they might request you to write all those things, and sometimes those things comes. But these things should not become part of your pleadings, etc. Or maybe for sure, even if you write in the pleadings, never bring them in the argument unless it is like very compulsive things. So, any questions so far? Ramchandran ji, Kapil ji. No? Okay. So, I think we have covered most of it, but a lot of time is like still there. I think we have. You should ask something. Otherwise, it's very difficult to run it for such a small topic. Anyway. Okay, so let's take a 10 minutes break and then reassemble again. And till then you can formulate the question well and good. Otherwise, I will prepare few more topics for you and continue it for like say half an hour at most max. Okay?
Okay. Okay, sir.
We'll rejoin in around 15 minutes. So
Okay.
5:25.
Fine. Fine. Sir. मेरा कैमरा और स्विच सारा कुछ ऑन है. What should I do?
Hello. Am I audible?
Yes,
Thank-
sir.
Thank you.
Yes, sir.
Forever. So we'll discuss two main topics. One, what things you should be knowing as a resolution professional regarding these three things. And what if the appeal goes further than NCLT and NCLAT? What are the criteria where the format is not applicable and what is to be done? So let me start with as an RP. As a RP, the resolution professional is functioning basically in three primary roles: interim resolution professional, and liquidator. In all three roles, he is mostly either applicant or respondent in interlocutory applications. Like, suppose there is one case of IBC, there must be 100 interim applications which comes filed before the NCL saying that RP has not done this, that, etc., etc. As a RP, his role becomes typically of a client unless he is representing himself. So the Indian law allows that you can represent yourself, RP can represent himself. For optimization of resources or for various reasons, the lawyers are engaged, which is a good practice because that allows you a lot of time and less of a hassle, because waiting for your case for hours and hours is a tough task. Now, when you are hiring someone as a lawyer, you become a client, and your first and foremost responsibility becomes of checking the facts. Whenever an application is being filed or any reply is filed on the behalf of the resolution professional, it is important for the resolution professional to check every fact written in that document. Because he might be wrong in terms of law, but if he is wrong in terms of the fact, the penalties are huge, the consequences are also significant. Two, he is signatory of all these documents. Because he is signing those documents, the primary responsibility is of the resolution professional and not of an advocate. Advocate is just presenting the case of the resolution professional, but he himself does not become the client. There is a segregation between the client and the advocate. So therefore, the primary responsibility of verification of the facts lies with the resolution professional. One. Two, after checking the facts, he must check the pleadings on all these parameters, which we have discussed so far. One, there has to be clarity on the facts, clarity on the legal issues, and clarity on what the relief they want. Similarly, when they are filing a response, their objection has to be clerical, extremely clear in terms of law. It should be backed by the facts, and the proper relief should be asked. A lot of applications are dismissed by the NCLT and NCLAT because the relief claimed in those applications are weak or cannot be granted by the tribunal. So, it is important for them to have the clarity on those issues. Another reason for which the applications are dismissed is lack of clarity and lack of specific section in the application in which that relief can be granted. Everything could be molded as a relief, but may not be granted by the tribunal. RP is regarded as a professional appointed by the tribunal, and therefore he is supposed to know the law. He cannot put his responsibilities on the shoulders of the tribunal. Say a claim is to be decided. He cannot say that I will not decide the claim, go and get it decided by the court. This should never be an approach of a resolution professional. The resolution professional should always be extremely careful in drafting their responses and replies to the stakeholders. The first thing first, if a mail comes in the mailbox of a resolution professional, it should be regarded as an invitation to the future application. Somebody is trying to build a narrative one way or another, which the RP will be and maybe, most probably will be, supposed to answer before the tribunal. So the response has to be categorical. Say you have been appointed as an IRP, and you write a communication to the ex-director saying that, please provide me this information. The response comes saying that I do not have the information. You can't write and say that, okay, I'll file an application against you. You must be inquisitive. You must treat all the communication to yourself as a potential precursor to an IA. And that's how it has to be responded. The second thing about the chronology of the events. By the time a case is filed and by the time it is about to be decided, maybe in the time period of say 1, 2, 3 years, 4 years, the 330 days is gone. He is supposed to collate the facts in respect of each of those applications. It becomes very difficult for a resolution professional or a lawyer appointed by the resolution professional. If the information is not systematically arranged, then to argue those applications before the tribunal. Therefore, collection of the information in a chronological order in respect of each application is important. Each message has to be replied, and it has to be replied in a manner to protect the interest of the RP. The RP, most of the resolution professionals take their job very seriously, and they are extremely serious about their remunerations. One must understand that the profession of a resolution profession is not a typical job or a work of a chartered accountant, post accountant, or a company secretary. It involves certain element of advocacy or lawyering in it. And in advocacy and lawyering, 100% of the fee is never guaranteed. Therefore, whenever such application is being filed by a resolution professional, they should be mindful of the fact that the court may not grant the relief. The other thing is, whenever those kinds of the applications is being drafted by the resolution professional, they must give the clear-cut bifurcation. See, some of the resolution professionals have filed an application that my fee has become 2 crores. Immediately, the judge gets an impression, how come? How come a person can get such an astronomical amount? Say he is only handling one. Take an example. What might be the rationale? A judge deals with the 50 CIRP proceedings in a day, and another person, his remuneration are very limited in a monthly in lakhs. And the person RP who is doing 2-3 assignments and each assignment is getting such a money. It creates an impression as if the amount which is being asked from the tribunal is disproportionate to the fee which is being charged. And it immediately gives rise to a suspicion of collusion between the parties. And therefore, whenever those kinds of applications are made, the bifurcation should be given, the rationale to be explained very clearly. Now, let's come to the next category of thing, which is claim applications. There are multiple applications which is filed before the NCLT regarding non-admission of the claims. Primarily, there are 2 grievances. First grievances is regarding the rejection on the ground of the delay. 2, the rejection on the ground of non-furnished, the claim is not made up. As far as the first is concerned, if it is a home buyer, if it is reflected in the balance sheet, if it is something like that, then they have to be admitted. One can remove a lot of litigation themselves by taking appropriate steps at this stage. 2, if the application pertains to the non-admissibility of the claims, whatever reasons are given for the rejection of the claims should be very specific. So, when it comes to defending those decisions, it could be defended before the court as a resolution professional or as a liquidator. Liquidator becomes a quasi-judicial authority. The resolution professional may not be, but still the role remains the same. The justification has to be provided. Thank you, Satisa, for your question. So, if in the delay condonation period of 90 days, if the claims are coming, they should be accepted. They should be accepted if they are reflected in the balance sheets or the financial documents of the company. In case they are rejected, then the first thing on the ground when it is cannot be admitted by RP because of the 90 days period, then the first thing is that if my Lord orders, I will admit those claims, I will condone the delay. So if that kind of answer is given, most of the problem is sorted out. The claims can be admitted beyond the limitation. The only thing is that the condonation power is normally exercised by the court. Some of the judges have practice of imposing the cost and then allowing the claims. They are allowed even like many years after. Some of them are like allowed close to the resolution plan. So those are the practices. Different tribunal, different judges has different parameters. So I think that answers your question, Mr. Sethi. So those kinds of application. In case there is a sequel to the question which says, I mean that claim is related to period prior to 2015 and the latest financials are not available. That means there is no backing of the claim and they can be rejected. There has to be a backing of the claim. It has to be maintainable. If it is not my financial, it is not available in the financial statement prior to 2015, clearly barred. But depends upon various factors because there are acknowledgements, emails, etc., etc. But if these are the only 2 facts, then they can be rejected. Now, the next category of the application which the RP has to deal with is the approval of the resolution plan. The approval of the resolution plan is a very critical application. It it has to give all the sequence which has happened so far. Then all the compliances which is mentioned in Form H, and then give his opinion, kind of an opinion or summarization in that application as well. The threshold has to be met. When that application is listed, along with that, all other applications are listed, as well as the objection to the resolution plan. It is highly recommended that when a RP is arguing that application, because the RP is filing that application of approval of resolution plans, he should prepare a chart of key facts and events, which can be easily handed over to the judges. That will make your task very easy. Another chart should be prepared about all the pending applications. That what is the application, who filed it, what is the relief sought, and your comments on it. So those applications get decided very quickly, and it makes the task of the resolution professional very easy. Am I clear so far? Any questions? Okay, thank you very much. So, one part. Then the job of the RP, after say the plan is rejected or whatever it's mean, he becomes the liquidator. During this entire period, the RP is drafting various minutes of the meetings. These minutes of the meeting are available to the stakeholders and has to be drafted with most relevant information in a chronological way, which could be understood by the judges. Because ultimately the judges who are deciding it, what happened, what transpired, etc., etc. So utmost care should be taken while drafting these minutes of meeting. Now, as a liquidator, the RP becomes quasi-judicial authority. By quasi-judicial authority, I mean that he becomes or he gets the power to decide the claim. So the way he decides, it attains finality to a certain extent, and it can be challenged before the NCLT. So all the rejections should be backed by proper reasoning. It should not be presumed, or it should not happen that simplicity or stereotype rejections are given. If the rejections are repetitive or a stereotype, they can be questioned. If they do not deal with the contention of the parties, that can be questions. And it can lead to a lot of delay in completion of the proceedings. In between, there are lots of other applications. The same parameters applies in all those applications. Now, assuming somebody goes from NCLT to NCLAT to Supreme Court, what is the procedure? What is the sections? What things has to be taken care of? The Supreme Court is the final court. The Supreme Court is supreme not because it's better than other courts. It's supreme because it's the final court of adjudication. In Supreme Court, there are two sections which is relevant for the purpose of the discussion. One is Article 136, special leave to appeal. And one is the statutory appeal, which is in the IBC. The difference between the two is the SLP is not a matter of right. The prayer in the SLP is normally, please treat this leave to appeal as an appeal. So if the notice is issued and court admits it, it will be converted into appeal. However, in case of IBC, the statutory right to appeal is given in IBC itself. This is very typical to certain forums, including NCLAT, Consumer Commission, where the right to appeal to the Supreme Court has been provided. What is the difference between the two? The difference is primarily in the form. SLP is a different format and appeal is a different format. In SLP, the form is given. In appeal, it's a non-standard, but it goes with the same ingredients, question of law, grounds, facts, etc. By the time the litigation reaches to the Supreme Court, the question becomes very narrow. Most of the issues have been decided. Only few are left. So it is important to be very precise in the synopsis. It is important to put forth the question of law in a very concise and the meaningful manner. Though this is an appeal, but in practice it is decided like an SLP on the first date. In Supreme Court, the record of cases dismissed on the first day is very high. Because even if there may be ground, even if there might be some legal question involved, the Supreme Court decides what to hear and what not to hear. Another thing is, since it is a Supreme Court, it is a last court, it is not supposed to give reasons for dismissal when the cases are dismissed on the first date. So typically you will see an order of 2 lines, 3 lines, 4 lines. Supreme Court is not accountable to any other court in India, and all other courts are accountable to the Supreme Court. The courts, because they are accountable to the Supreme Court, they are supposed to give reasons for their judgment. And since Supreme Court is not accountable to anyone, they are not supposed to give the reasons for rejection. And therefore, the stakes are very high on the first day. So all the precautions to be taken when the cases are listed before the Supreme Court. The stages involved, the notice is issued, other party is called, and the case is decided. It is important to know that as we have seen in NCLAT rules, there is a requirement of a prior service. When the notice is issued, then it has to be served again. And the other party gets the right to give response. This typical process is repeated in almost every application, almost every case. Because it pertains to the rules of natural justice. In sum and substance, the natural justice says that no person should be condemned unharmed. It also means that one person, if somebody wants to hear, then he has to be told that what are the allegations, so he can reply. And a rejoinder can be followed if new facts comes. So this is a part of the natural justice process. And this has to be kept in mind in all proceedings while replying to the IAs, while replying to even to the emails. It is not that since the RP has been entrusted with certain powers, it is without responsibility. In fact, the RP is being scrutinized at every stage by every stakeholders and a regulator. Anything can be called in question at any point of time. Even the records can be scrutinized, which is happening frequently. And therefore, it is important that all these things should be mentioned very categorically. There is another document which is relevant, is Section 99 report. Many of the resolution professionals have become resolution professional for the individual. They are supposed to prepare the report. There is no format prescribed. However, what is happening is that simpliciter, the people are putting the allegations as disclosed by the financial creditors and giving the reports. Those reports will be questioned by the court, and therefore it is important to draft them after taking into consideration not only the facts provided by the bank, but also by the personal guarantors. Because on that recommendation, court is going to decide the case. The idea that the financial creditor has to defend is very vague. It should not be. It is particularly the responsibility of the RP to defend his own report. That brings us closer to most of the applications which is to be filed by the RP against the RP. The last but not the least or the important one is the PUFE transaction. Avoidable transaction. In the avoidable transaction, one of the major challenge is that it has a grave adverse consequences against the person, and therefore the level of scrutiny is very high compared to what is required at the admission stage of Section 7 or Section 9. Why it is so? Because if somebody is found to be guilty, he is disqualified from doing many things, including getting back his own company. Therefore, merely for the sake of filing, the application should not be filed. It has to be backed by facts, data, and all the transactions has to be segregated in those applications. Typically, what is a practice nowadays, because there is a compliance requirement, the applications are being filed. Sometimes these lacks critical facts which required to very much required by the tribunal to decide those particular cases. And it becomes very difficult when those applications are listed for the RP to decide. It is advisable in all those draftings of the avoidable transaction applications, there has to be a chronological events. There has to be evidence, direct or circumstantial. Take an example. Can you hear me? Anybody can respond? Yes. Okay. Thank you. I think that something happened, like the meeting got disconnected. In fact, it's a monologue, so perhaps Zoom got bored. So there has to be chronologically. It has to be backed by. I was taking an example of a land parcel. If it has been transferred for a value lower than the market rate, this is the allegation. Then in order to reach to this conclusion, one must specifically write multiple things. One, this is the land. This is the measurement. This was the valuation report by the financial institution at the time of giving the loan. This is the price of the comparable lands on the marketplaces. These are the registries of the comparable lands. And based upon this particular price point, this is hugely in variance with the actual market price. Plus, you have to factor in if there is any existing litigation with that sale access. Merely because the price is X and it has been sold at Y does not make your application good unless it is supported with all those informations and the documents. And thus, every application of yours on those transactions should be properly backed with the facts and events. I think, let me know if any of you have any questions. Any questions? Okay. If there are no questions, then you can send me if you have any other questions on the email. And in case you want any other answer or you want to discuss with me, I have put my numbers in the chat box. And any comments on the session, most welcome, positive, negative feedback. Okay. Thank you very much, Seti sir.
Thank you, Manisha. It was really insightful session, a very practical one.
Thank you, ma'am.
Thanks.
It was more or less a monologue, but few people
Yes,
sit
I do
on the
understand it
special
was.
text.
Yes. Actually, it's very difficult. So I think it in IP, very few are there who are actually in practice.
True.
They may be in consultancy and all, that may be the thing, but really you have good exposure of NCLT, and thank you for sharing your experience. Thanks a lot.
Thank you very much.
Thank you. We look forward to you for further any guidance whenever it is required.
Most welcome.
Yeah, thank you.
Thank you, Kapil ji. And thank you all of you who have attended the sessions. I request the organizers to conclude it if it is allowed. Anybody there from the ICS? I think they have left. So. I think there is no one. Yeah. Thank you, Preeti ji. Anybody from Institute, ma'am? Could you please close the session?
I think no one is there at the laptop.
Yes.
So they are logged in, but
They are not actually in. They might be busy somewhere else. Might be.
Yes, I think that is the case. I'll just call them and ask them. Mm. They should give their numbers. Okay, I'll wait. I'll try a couple of times.
I think, sir, you can end the session yourself too, isn't it?
I don't know. If somebody is still trying to give their CPA hours attendance, then it will get some impact. You can leave. I'll just stay for 5-10 minutes more.
Okay, sir.
Because whatever happens is like everybody is like many of them are joining only for the credits now. They should not be getting adversely impacted.
Okay. I don't think so it would be impacted, but okay, let's wait for another 5 to 10 minutes. Okay.
They just switched on the computer and that.
Manish sir, are you here?
हाँ मैम, प्लीज कंक्लूड कर दीजिए सेशन को.
Okay. Thank you very much, sir, for your valuable time and sharing your learnings and thoughts on the topic.
Thank you.
Thank you. Thank you.